Welcome to our Arizona Revised Statutes video library. I'm Shawnna Riggers, Managing Attorney at Arizona Family Law Attorneys. My goal is to take this somewhat dry information, make it a little bit more entertaining, and also provide you with information regarding the laws that are applicable to dissolution, parenting time, custody, child support cases here in Arizona. This is being filmed in 2023, so it's important that if you're seeing that afterwards, that you double check the statute to make sure that it is the most current version. And if you have any questions regarding any of the material, as always, please feel free to reach out to us here at Arizona Family Law Attorneys, where we provide peace of mind as there is no substitute. Hi, I'm going to read this statute and then at the end I'll discuss it. If you have questions, reach out to me directly. 25-318-03, Human Embryos, Disposition, Responsibility for Resulting Child Definitions. A. If an action described in 25-318 involves a disposition of an in vitro human embryo, the court shall 1. Award the in vitro human embryos to the spouse who intends to allow the in vitro human embryos to develop to birth. 2. If both spouses intend to allow the in vitro human embryos to develop to birth and both spouses provided their gametes for the in vitro human embryos, resolve any dispute on a disposition of the in vitro human embryos in a manner that provides the best chance for the in vitro human embryos to develop to birth. 3. If both spouses intend to allow the in vitro human embryos to develop to birth, but only one spouse provided gametes for the in vitro human embryos, award the in vitro human embryos to the spouse that provided gametes for the in vitro human embryos. B. If an agreement between the spouses concerning the disposition of the in vitro human embryos is brought before the court in an action described in section 25-318, subsection A, the court shall award the in vitro human embryos as prescribed in subsection A of this section. C. The spouse that is not awarded the in vitro human embryos has no parental responsibilities and no right, obligation, or interest with respect to any child resulting from the disputed in vitro human embryos unless the spouse provided gametes or the in vitro embryos and consents in writing to be a parent to any resulting child as part of the proceedings concerning the division of the in vitro human embryos. D. If the spouse who is not awarded the in vitro human embryos does not consent to being a parent as provided in subsection C, any resulting child from the disputed in vitro human embryos is not a child of the spouse and has no right, obligation, or interest with respect to the spouse. E. A spouse who provided gametes for the in vitro human embryos and who does not consent to being a parent as provided in subsection C of this section shall provide the spouse awarded the in vitro human embryos as provided in subsection A of this section with detailed written non-identifying information that includes the health and genetic history of the spouse and the spouse's family in a document that is separate from the document containing identifying information. F. For the purposes of this section, 1. Gamete means sperm or ovum. 2. Human embryo has the same meaning as prescribed in section 36-2311. And 3. In vitro has the same meaning prescribed in section 36-2311. This is one of Arizona's newer statutes. It came out a few years ago, and it is very important that if the parties have had an in vitro process in the past, that they make sure that those human embryos are in fact divided in their divorce decree. If one person wants to use them and the other person doesn't, based upon this statute, the court is going to award the person who is going to use those embryos to bring a child into this world. They're going to be awarded those embryos. If they both want to do it, then the court's going to have a difficult decision on who they think is most likely to actually bring a child into this world using the embryos. The thing that is interesting about this statute is that even though if in this instance where both parents have provided their biological sperm or ovum for the human embryo, one of the parents can actually choose not to be a parent. They would have no association with their child, no parent-child relationship, and no obligation to pay child support for that child unless they agree in writing to be a parent. So I do think that that is an important protection under the law that does make it more fair and equitable when the family situation has significantly changed from the time most likely when these human embryos were created and now through the divorce process, so that one spouse can choose not to be involved in parenting moving forward.